Pardon?
Who's responsible for placing the defendant on the database?
The state. It is not set forth in the statute that any particular department or apparatus of the state has that responsibility, simply that it be done. And I would submit that that was an actual intelligent decision by the legislature, that various political subdivisions throughout the state would have procedures for doing that, that they may require the district attorney's office to clarify who is or is not appropriate to be placed on that list, or they may just rely upon the sheriff's office to do it as an automatic procedure. But that would be up to the individual political jurisdiction and not dictated by the legislature. The legislature basically said, get it done. We don't care how you do it. We just want it done.
Mr. Mosley, what's the consequence of the state writ large not placing the escaped defendant's name inside of the database? What's the consequence?
Well, in terms of the statutory consequence, the statutory consequence is that the surety would be relieved of any liability on the undertaking.
Well, okay, it doesn't say that. It says not liable for any undertaking.
Correct.
So it doesn't quite say any liability for any undertaking. So how do we interpret undertaking? It looks to me, when I read this statute, I have to interpret two words in particular. One, I have to, not me, the court, the parties, has to decide what the meaning of the word undertaking is to a reasonable reader at the time of the enactment, and then perhaps any. And so I'm curious about that. But how do we define undertaking?
Well, Your Honor, we actually have case law on that. Okay. And I would be more than happy to brief that issue at a later date.
Well, does undertaking include the amount of the bail?
Yes. As a matter of fact, that is exactly what the undertaking means. The undertaking is the contract between the state of Tennessee and the bail bondsman.
Okay. That's
what they refer to.
How do we know that? Is that defined in case law?
It is.
What case?
Your Honor, I would have to probably go through there, but that is an issue, I believe, in State v. Allen and in State v. Blankenship that was discussed.
Okay. Is that the holding of those cases?
It is not. That is an issue that is discussed in passing. That essentially what occurs is that some of the old statutes, old cases talk about the undertaking. And the undertaking in this case is the contract between those parties, the state of Tennessee on one hand, the surety and the defendant on the other.
Okay. Well, are there other undertakings? I mean, when the statute says any undertaking, that seems to imply to me that there's at least more than one undertaking. So what other undertakings are there? Well,
Your Honor, in this instance, what I would say is that you might have multiple undertakings under a particular case. And that, what I mean by that is that in General Sessions Court, you'll have charges listed out individually, such as,
$5,000 bail
on this.
Okay.
And so you may have a number of cases in the circuit court that are consolidated into one,
okay,
a number of charges. And so in this case, what I would say is that once those cases are consolidated, once those charges are consolidated, that would be the any undertaking.
Okay, all right. So as I understand the procedural posture of the case, the court orders the final forfeiture. It's unclear to me if it's January 23 or January 26, but let's say January 23.
Regardless, either one.
Right.
I don't think it has any material bearing on this.
It probably does not. And then the first request, then it looks like from the surety is February 6th?
20 days later, approximately, yes.
Okay. And so your friend on the other side says, well, you've waived it. You should have appeared at the hearing on the 23rd. You've waived it. It seems to me that the logical consequence of your position is that you didn't have to file a request at all, is that the obligation was on the trial court to determine whether the defendant's name had been placed in a database, and that you had no obligation at all to request relief at any time.
If Your Honor so holds, then I'll be more than happy to take that.
Well, Mr. Mosley, I'm not saying we're there. I'm asking, though, I mean, is that the logical consequence of your position?
I do think that it's a condition precedent. I do think that the burden is on the state to do this act, and because this act falls after the date of the syrophagus.
Right. So,
because the record is set at the syrophagus.
So could you have, on the 11th day, could you have come in and filed a motion to be relieved?
Absolutely. And more importantly,
So even though the final forfeiture, even though the conditional forfeiture is not final for 180 days, you believe that under this statute, you could have sought to be relieved on the 11th day
if we had known on the 11th day that this had not happened,
Right.
then I think we could have. And indeed, I think that is the intent of the legislature, is to say, look, you've got a period of time. And they've amended the statute since to say 10 business days, and they may amend it again to give, that certainly is within the prerogative of the legislature. But fundamentally, the issue is, in this case, they didn't do it. They didn't do it until January 31st. I mean, so this was not, a matter of missing it by 5 days. It's more a matter of missing it by several months.
Well, or from your perspective, I guess, they first placed the defendant in a database after the final forfeiture order had gone down.
They placed it on NCIC on January 31st. That was General Dugan's testimony.
But that was after the final forfeiture issued, from the best we can tell from the
From the
record.
best we can tell, yes.
Would it not have been incumbent upon the appellant, though, to alert the court prior to the entry of the final forfeiture that the statute had not been complied with?
If we had known at the time, that would certainly have been the best practice.
Well,
I don't think that it's fatal to the case at all, and for two reasons, Your Honor. First one is that even though the entry of the final forfeiture took place on, let's say, January 26th, if it had been done in the normal course of business, that would not have been the last word. That would not have created an immutable object that is not subject to further action. Because
the trial court can relieve the final forfeiture, right?
within 30 days, we could file a Rule 59.04 motion to set aside the final forfeiture order pursuant to the rules of civil procedure, and ask that the court do so. So if the court had done so, we would have come in with the same exact motion, simply referred to Rule 59.04, and said that we're entitled to relief because of this. And it wouldn't have changed anything with regard to the motion itself, except to add that additional ground.
So is that your position, that any time up until 30 days after the entry of the final forfeiture?
Well, we've got a second. The bondsman is not without further recourse even then, and that is under 4011-204. I didn't brief it because essentially Your Honor's question pretty much begs that answer. Is there's also jurisdiction which to some extent
Is that exoneration?
Exoneration after even the entry of and payment of the final forfeiture, the bondsman can seek some remission. There's a 5% or $1,000 that's paid to the clerk as a fee, but that could happen. And again, when you have a situation where, as is I think often the case, the left hand's not talking to the right hand. And that is that I don't think the state knew what the status of this case was, or the district attorney general, I should say, didn't know the status of the entry until well after all this had come out. And it was only when they started digging that they became aware that this hadn't been done and that it should have been done.
So this issue, and I may be oversimplifying in my own mind, but it comes down to this in my mind, perhaps. Can the protection here in subsection D be waived by the surety? So it's a provision that the legislature has put into law for the express benefit of the surety. Is it a protection the surety can waive?
Well, I would say I would not characterize it as a provision for the express benefit.
Okay.
Because
All right,
I think the
all right,
purpose of that is to.
Mr. Moses, I'm sorry. Is it though, let's take that off the table. Is it though a provision that can be waived by the surety? Is
No,
it a
I don't
protection that
believe
be
it
waived?
can.
So it's essentially a subject matter jurisdiction?
It is. And the courts have said that in terms of the forfeiture proceedings, these are statutory and exclusive. Sure. So the court has to follow its statutory proceedings. And when you have a statutory proceeding like this, or provision that says, as this one does, that the liability is removed, that essentially it's taken away. Now, I would say that doesn't prohibit the surety from making the arrest. Because while the liability is gone, the authority of the surety to make that arrest still exists. And I think that may be something that's a little too technical at this point in time, but I will stepping back a little bit, the provision that's in there, I think, was intended to incentivize the state to follow through with their record-keeping provisions, their entry provisions. That was the express purpose of it. It was to ensure that they made sure that that happened, and that if it didn't happen, there would be a consequence.
It would make sure that would happen, so if the defendant was encountered in another jurisdiction, they would be arrested by law enforcement, and the surety wouldn't have to go get them.
Well, under 4011-201, we would still have to pay the cost of transportation to bring them back here.
Sure, but you wouldn't have to go find them. I mean, law enforcement would be doing that at that point, in essence.
And very often, up till now, my clients were able to find the defendant,
Sure.
but if they weren't entered into NCIC, then it didn't matter because local law enforcement wouldn't give any assistance. It was only when there was an entry into NCIC that would do this. Very often, that was the situation that we were looking at. And even now, when you have a situation where there is a restriction placed on NCIC, such as a geographical restriction saying we're going to extradite within the state of Tennessee, if my client finds somebody in Florida, they'll say, yeah, we see that he's on NCIC, but he's Tennessee only, so we're not going to let you take him.
And the statute doesn't speak to that.
It does. The statute says that they are to be placed on NCIC without restriction. Without restriction. So there is a provision in there that charitably could be looked at and said that if they don't do that, then they haven't complied with the statute.
Without limitation? Is
Without
that the
limitation.
language?
Without limitation.
So it's your position that this statute requires the state to place any fugitive for justice, all the way down to a B misdemeanor, full extradition, all 50 states? Is that what you're saying without limitation means?
That is what I say without limitation means. And
If
it's
they don't do that, you don't have to pay.
A or B misdemeanor that are violent or sexual in nature. Not all A or B misdemeanors, but only those that are violent or sexual in nature. So, and NCIC has a provision in it that says all felonies and serious misdemeanors. And the state of Tennessee has determined that that is violent or sexual in nature misdemeanors.
Thank you.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the court's denial, or this court's order of final forfeiture because the surety failed to provide good cause for why it should be relieved of that final forfeiture. I think it's important to start out with a timeline of what happened and who was informed of what and when. So starts off on December 19th of 2022, based on what we have in the record. That is when the defendant, in this case, waived his right to a preliminary hearing, agreed to waive his pending criminal matter over to the grand jury. About a month later, so January of 2023, after the court set a $7,500 bond, first out, the surety on this appeal posted the defendant's bail. So this is January of 2023. They've kept him on bail. In July of 2023, the Madison County grand jury returned an indictment charging the defendant, in this case, with various offenses. The arraignment was scheduled to happen on July 10th, 2023, and the defendant in this case failed to appear. So the trial court, acting within its discretion, issued a capias for the defendant. So that's, with this defendant. With regards to the bonding company, it issued a shire fascis, and I apologize if I'm mispronouncing that. I did not take Latin, but it issued that notification, which told first out, the surety in question here, that the bond would be forfeited unless it provided a valid reason to the contrary within 180 days. So that was served to them. The next time that we have is sometime in January of 2024. So 6 months later, 180 days later, there's a hearing. And in fact, it seems that there's a status hearing that is reset for a week so that the surety can be there. And I think it seems that on January 23rd of 2024, there's a hearing on final forfeiture.
There's no notice in the technical record that the surety received alerting them to the January 23 hearing? Can you point to anything that, I mean, I don't think the surety is alleging they didn't have notice of the hearing. I haven't heard that argument. But when I'm looking through the record, I don't see any notice given to the surety. So was there notice given?
So it appears, based on the trial court's comments from a later hearing, says we initially scheduled this for January 16th,
it's no doubt.
and I reset it so that you could be here. So that's all we have, to the extent that the record is sparse. Otherwise, it's the
They
failing
don't
is on
raise
the
the issue.
defendant.
I was just curious. Okay.
It doesn't appear to be a notice issue, but there is a hearing. The surety, no counsel or representatives from the surety arrived to present that good cause or that valid reason why bond shouldn't be forfeited. And so the court orally finds, I'm entering, final forfeiture, we're going to enter an order today. 2 weeks later is when the surety issues a motion to be relieved, relying on Tennessee Code annotated 4011-139. And at the hearing and ultimately the order denying that relief, the trial court says this is untimely. No, you waited too long, it's on you. So that's sort of where we have on the timeline.
So if the surety had appeared on January 23 and said subsection D of 139 provides that I'm relieved from any undertaking, would it have been proper for then the court to say, I agree, you're relieved from any undertaking?
I think that would have gotten into a statutory analysis of what 4011-139D actually does.
Exactly where I wanted to go. Thank you. So your friend on the other side says the case law is crystal clear. I may be embellishing a bit. The case law is clear that undertaking includes the amount of bail. And in fact, I thought I heard Mr. Mosley say that's exactly what undertaking is. When I pushed him on it, he said that's what it is. So what is undertaking? Does undertaking include an amount of bail?
That is a complicated question, Your Honor. I think with regards to 139D, that's a matter of first impression, and we don't actually know. I have
That's
found,
the question in the case, though, right?
I think it's a red herring. I think
think so?
because they didn't meet their burden. And I'll point to, because one of the questions was whether the obligation is on the trial court to sort of make this finding or make this inquiry. No, Henry Sanford and Sons bonding makes crystal clear the burden is on the surety to prove why their petition for relief should be granted. So they have to do that. And I think it's important here because 139D has a prerequisite that triggers the release of liability from whatever the undertaking is. So I don't think it matters what the undertaking is whether that prerequisite was triggered and whether the surety proved that. And here we don't have that.
Whether the surety proved that the defendant had not been listed in a database?
Yes.
Okay. How does, all right, okay. All right.
It's a little bit of a question, but I think they can get up and say, Judge, we don't have any proof that they can almost prove it by a negative, but we should be relieved of this liability within the 180 days. We're giving you notice we should be relieved of this liability because the state failed to put this defendant in some national database within 10 days.
So what I'm hearing you say, and let me see if I can repeat it back to you, you're saying that 139D is a right that can be waived by the surety and is not a limitation inherently upon the power of the court to order a forfeiture.
It's certainly not a limitation on the court's inherent power. I think it is, I would categorize it as sort of an affirmative defense or a affirmative valid reason which the surety can rely on to relieve them of liability of whatever this undertaking is.
Is that because the language of the statute that says a surety is not liable versus language that would say the court shall not issue?
I think that's part of it, and I think part of it is this prerequisite, this triggering event. It doesn't just say universally that they are not liable. It says if the defendant is not put on a national database, then they're resolved of some liability. And so that is a factual determination that has to be proven, again, because the surety has the burden. It's on the surety to establish it. They didn't show up to this hearing, and so they didn't meet their burden of proving why they should be relieved. I think if they had, and if the state had at the forfeiture hearing sort of conceded, yes, Judge, like we didn't put them on, they would have a much stronger argument on appeal. But
So your friend on the other side says, but I had a 30-day out clause under the rules of civil procedure. How do you respond to that?
he could have, or the surety could have utilized that.
I think he says he did. Within 2 weeks, he filed a motion to reconsider.
So there's a motion to be relieved, but we're not on appeal of that, and the defendant doesn't have an appeal as of right from that. We're on appeal as of right from the initial entry of order of forfeiture. And to the extent that this court can review the denial of the motion to be relieved insofar as it is a motion under the rule of civil procedure. And the record will be more accurate whether he quotes that rule and establishes that the motion to be relieved is pursuant to that. But insofar as it is, the trial court properly exercised its discretion and says, I don't want to do that. You waited too long. I gave you 180 days. In fact, I gave you 180 days and then reset the case. I don't find good cause to grant you relief. And that's not an abuse of discretion.
Could the surety have come in on the 11th day after the defendant wasn't placed in a database and asked to be relieved?
I believe so.
Okay.
Again, the sire fascis says you have up to 180 days to provide valid basis. So if that 11th day is triggered and that prerequisite is triggered, they could come in then and say, here's our good cause. And I think they would be able to be relieved.
Okay.
The simple fact of the matter is that they didn't do that here. And to the extent they availed themselves of some other avenue, the trial court properly exercised its discretion in denying relief because of their failure to come in a more timely manner. And I don't think that the issue of the nunc-pro-tunc was raised here, unless this court has questions of the order being entered nunc-pro-tunc. We can rely on our brief for that, but state submits that the trial court properly exercised its discretion in finding that the surety had failed to meet its burden of proving a valid reason for release of liability at the time of final forfeiture.
Do you have any idea how many state or federal lists or databases are out there?
I'm not sure how many are out there. I know I dug into the legislative history of 139D a little bit, which is why to your question, Judge Greenhalgh, I'm not sure what the undertaking is. There's some comments in the Criminal Justice Subcommittee of the House that, okay.
You can talk, it's not going to be
Well,
persuasive, to be
it
honest
gets
with
into,
you.
okay, I
I
find
don't
it
care
a
what the
little.
legislature thought they were doing. I care what a reasonable reader would have understood at the time of the enactment.
Yes, Your Honor. But to your question, Judge Holloway, I think that they were focused on something like NCIC. There's no statement out there of what databases are there, and I think it was left intentionally vague so that there was a little bit of wiggle
But
room.
without limitation, it's pretty broad.
I think it's certainly broad, but I mean, I feel like that's maybe a rabbit hole that this court doesn't need to go down with regards to this appeal.
But there are a lot of rabbit holes that I really want to go down and explore. This without limitation, any available database. I mean,
They are juicy
your
issues.
Point is well taken, though.
And you know, if this court wants to conduct some independent research, it's certainly welcome to. But ultimately, the appeal should be, or the order should be affirmed because the surety did not meet its burden. If there aren't any further questions, we ask that you affirm. Thank you.
Thank you. Thank you.
Mr. Mosley?
Thank you, Your Honors. Very briefly,
Can I hijack your argument just a minute before you get into full rebuttal? So your friend on the other side is raising a jurisdictional issue for us, and that is he is saying that you are appealing the court's denial of your motion essentially to reconsider or to relieve the bail, and that there's not a Rule 3 under the rules of appellate procedure avenue for you to appeal that. You could have appealed the final forfeiture, but you're not appealing the final forfeiture. You're appealing the court's denial of your motion to reconsider. What say you on that?
I say that I am appealing the final forfeiture insofar as the final forfeiture was a denial of my request for relief.
Well, the final forfeiture that went down on the 23rd of January, you're appealing the court's later order in March.
Which I contend was a motion to alter or amend under Rule 59.04.
Okay.
Now, it's odd because the motion to alter or amend was filed before the order was actually entered, because entry of an order is under the rules of civil procedure has a very specific meaning and requirement. And that meaning and requirement is that that it be a final disposition written down, signed by the judge, and all parties, or signed by a judge and certified by the clerk to go to those other parties. That didn't happen because the judge for whatever reason, was relying upon the state to draft that, and that didn't happen. And in good faith, I contend that. But at the point in time when I filed my motion, there was not a written order to alter or amend. All we had was the actual, to be perfectly honest and frank, on the day that we showed up, it was listed as a final forfeiture day for this particular case.
Okay, that's fair enough.
So at this point in time, the entry of the final forfeiture is contemporaneous with the entry of the order denying relief. And such, I say that it is entitled to Rule 3 appeal as of right. I will say that I did take a look at the Indemnity Insurance Company of North America versus Blackwell case, and the court in there said a bail bond is an undertaking by the surety into whose custody defendant is placed that he will produce the defendant in court at a stated time and place. So relying upon that and the language of that case and the cases that similarly hold, as well as the language of 4011-122, which talks about an undertaking being a written, a signed undertaking being taken outside the bounds of the court, I would say that in this case, an undertaking very clearly means that we were referring to the bail bond itself.
What about the part about until the defendant appears in court that you just read from whatever case that was?
Well, and that's where the liability comes into place. Because if the defendant does not appear in court, then there is a monetary liability. Now, under the provisions of 4011-139D, that liability becomes null and void.
But the way I heard you read that, and again, I've just heard it one time, is that's part of the undertaking.
Yes, that is the undertaking. The undertaking is produce the body of the defendant, and if you fail to do so, then you are required to pay a penal sum to the state of Tennessee.
All right, there's another statute, and I don't, not that it might mean anything, it's 4011-317, and it says something, and I don't have it in front of me, it was in another case, but bond, bail, or any other undertaking. It seems to separate bail and bond possibly from any other undertaking.
Well, some of the older cases made a distinguishing remark between bail that was taken inside the presence of the court, and that was bail, and an undertaking was a written instrument that was taken outside the presence of the court. And the courts basically did away with that distinction. They said that there's no longer such a distinguishing factor between those two. They're both considered undertakings under the law. And that, I think, is what we have. Very quickly, I do want to say that my friend on the other side said that there was no evidence that the defendant had not been placed on NCIC. I would refer to page 3 and 4 of the transcript, in which on line 12 beginning, yes, Your Honor, the surety filed a motion pursuant to the new law which amended 4011-139 to add a new subsection D which provides within 10 days any person that fails to appear after July the 1st shall be placed on NCIC or any available state or federal database within 10 days. If that fails to happen, the surety is relieved. Well, do you have any proof, the court? Well, do you have any proof that that failed to happen? Mr. Mosley, Your Honor, I believe that it is uncontested that it failed to happen. I've spoken with the district attorney's office and they acknowledge that that didn't happen. General Duggan, that's a true statement, Judge. We confirm that Mr. Nelvis's bond wasn't entered into NCIC until January the 31st of 2024. I would respectfully say that the proof is in there. It's uncontested. The state has already acknowledged the fact that they failed to do what was required by the law. That's not an issue. The only issue is the application of the law. In this case, I think that the court below did not do the right thing.
NCIC doesn't help the state if they enter it in that, because you also got to enter in any other available state or federal list or database without limitations. How many are there?
Your Honor, I'm aware of only 3 that would fall into that category.
The without limitation category?
Well, Your Honor, I think the limitation refers to the method of entry, not necessarily the database itself. That essentially what you cannot do is you cannot place a restriction on that. But that, I think, does go beyond the scope of this particular appeal.
So if the, and I have no idea how many state or federal lists or databases there may be, But if let's say, there's 50 states and one federal, I don't have any, that's 51, so you list them on 49, and the federal, you haven't complied with this act, is that what it says? And the bondsman gets out out of liability after 10 days?
Well, Your Honor, I think that the true distinguishing database that everybody's concerned about is NCIC.
Well,
And
the
they may change-
lobbyists apparently put all these others in there. That's what concerns me. I have no idea what that means. But if it does mean what it says, it may be impossible basically to comply with.
Well, I think in the appropriate case that might be raised up, and the state might argue that. But in this case, the only database that we were concerned about was NCIC. And in the motion for relief, we contended that was an appropriate database under the statute that was created by the federal government, and the state did not push back on that. They acknowledged the fact that that was indeed an appropriate database. The court did so as well. If there are no other questions.
I've got it, thank you.
All right, thank you. Good job,
Thank-
both of you.
Your Honor, thank you for your
Interesting.
time, and we appreciate your patience.
Thank you, counsel.
Anything else, Madam Clerk?
No, Your Honor.
All right, we're going to just sit here a little bit longer, right? No, sir. April Fools?
No, sir.
Okay.
All right.